Hello and welcome to this video lecture on sports trademarks, the special protection of Olympic properties, and ambush marketing, which is part of Unit 9 of our program on sports law.
I'm Aju John, and in this video lecture, we will examine the trend of governments extending additional protection to the marks, logos, and symbols of sporting events in order to protect the investments made in sporting events. We know from the reading material to this unit that sponsorship accounts for one of the greatest sources of revenues for the sporting industry. Companies pay vast sums of money for a limited license to use the logos, marks, and symbols associated with sporting events. For example, the Coca-Cola company is reported to have paid around $100 million for the limited license to use the Olympic logo consisting of the 5 intersecting rings and other Olympic logos and symbols just ahead of the 2012 Olympics at London. Composite logos, which communicate the association between the Coca-Cola brand and the London Olympics, showed up all over the world in billboards, television advertising, and Coca-Cola's marketing material. You can see some of them on your screens right now. Obviously, this limited right to be able to use the Olympic logo is only valuable to the Coca-Cola company if that right is exclusive. If another manufacturer of sugary carbonated drinks, say Pepsi, was also allowed to use the Olympic logo during the same period, Coca-Cola would definitely not pay the International Olympic Committee $100 million for that right. At least part of the reason this right is so expensive is because Coca-Cola does not want Pepsi to exploit any association with the Olympic Games. Therefore, we can see that so much of the value in a sponsorship agreement is packed into these logos and symbols and marks. And these revenues are therefore dependent on the International Olympic Committee's control over these marks and logos and symbols. In the reading material to this unit, we learnt about the importance of trademark law in helping the organizer of a sporting event maintain its control over the symbols, logos, and marks. In India, the owners of such identifiers can register them under the Trademarks Act 1999, provided they meet certain criteria. Under the statute, the owners of registered trademarks can approach the courts to protect them from and remedy any infringement of trademarks. Even if the trademark is not registered, the owners can approach the court for a remedy if they can establish the tort of passing off. Trademark law, however, has two major disadvantages. On the one hand, trademark law only protects logos, marks, and symbols. There are other ways of associating with a major sporting event. Secondly, by the time that it takes to activate trademark law, approach the courts, and get a remedy, the damage would already have been done. Sponsorship contracts are very time sensitive, and trademark law is sometimes not responsive enough. Because of these two reasons, the sporting industry has lobbied national governments very hard for additional protections for the investments that have been made in sponsorships. They want to expand the scope of legal protection beyond logos, marks, and symbols, and they want protection that is more responsive than the court system that has been activated by trademark law. Now, if you notice the countries that have hosted marquee sporting events such as the Summer and Winter Olympics and the FIFA World Cup of Football in recent times, you will notice that these countries offer the organizers of these mega sporting events, in addition to great infrastructure and spanking new stadiums, they offer additional legal protection to the amounts of money that have been invested into sponsorship of this sporting event. The starting point has to be the Nairobi Treaty on the protection of the Olympic symbol. The Nairobi Treaty was entered into in 1981. All nations who are party to the treaty have to take measures to refuse to register or invalidate the registration of any sign consisting of or containing the Olympic symbol and prohibit their commercial use without the authorization of the IOC. In countries where the treaty applies, therefore, symbols containing the Olympic logo have to meet a higher standard to qualify for registration. However, any commercial use of the Olympic logo need only meet a lower standard to qualify as an infringement. While India has not made a law to give effect to the Nairobi Treaty, if you read Section 9, Clause 2 of the Trademarks Act 1999, with Entry 21 of the Schedule of the Emblems and Names Prevention of Improper Use Act 1950, the Olympic symbol cannot be registered as a trademark in India. In the United States, Section 110 of the Amateur Sports Act of 1978 prohibited any symbols or marks from falsely representing association with the Olympics without authorization from the IOC. Similarly, the United Kingdom has the Olympic Symbols etc. Protection Act 1995, which was amended by the London Olympic Games and Paralympic Games Act 2006 after London won the bid to host the 2012 Olympics. The amendment created a new type of intellectual property right called the London Olympic Association right and a corresponding infringement called Unauthorized Olympic Association. It was an infringement of the London Olympics Association right for a trader to use advertising to suggest to the public that there was an association between the London Olympics and their goods, services, or business. Australia has the Olympic Insignia Protection Act 1987, and Canada has the Olympic and Paralympic Act 2007, which offer a similar level of protection to the IOC's intellectual property. Ahead of the 2016 Olympic Games that will be held in Rio de Janeiro, Brazil has enacted a law expressly prohibiting the unauthorized use of the Olympic symbol even for non-commercial purposes. In South Africa, Section 15A of the Merchandise Marks Act empowers the Ministry of Trade and Industry to designate major sporting events as protected events. This prevents other traders from obtaining special promotional benefits from these events or being associated with those events without becoming sponsors. Ahead of the FIFA World Cup that was held in South Africa in 2010, the World Cup was designated as a protected event. From these examples, we can see the beginning of the development of a new right known as the association right. This right has started developing around the major sporting events in the world, and in response to the sporting industry having demanded protection that is greater than the protection available through traditional trademark law. Using this right, the organizers of sporting events are able to prevent non-sponsors from associating with these mega sporting events. This brings us to the end of this video lecture. Thank you for watching.
In the next unit, we will learn about media rights and the exclusivity of sports broadcasts.